Again, good afternoon and welcome. My name is Davies. I'm a partner in the BDB Pitmans insurance and DR team, and I'm responsible for dealing with advising businesses and insurers on defence of liability claims and also health and safety regulatory compliance. This is the latest in our series of webinars. And today I'm going to be talking about COVID-19 top tips for employers. There is a Q&A button which you can raise questions on, and what I'll do is go through our slides and deal with questions and answers at the end of that, which will be in perhaps about 35 minutes time or so. There'll be plenty of time for questions and answers, and also of course we'll be very pleased to deal with follow-up questions. So just to start, I'm going to be talking a little bit about the legal framework around the employer's health and safety obligations during COVID-19 and the implications of COVID-19 in terms of risk assessment, control measures, health and safety for remote working, and providing some top tips for employers to consider, and also alongside all this bearing in mind penalties for potential breach of health and safety obligations, which is now becoming more and more a consideration for employers, as we've seen pinch points arising in the last few weeks, in particular in areas such as Bradford and Manchester, Leicester, where there are local control measures being introduced, and the HSE have been taking particular interest in those areas and doing spot checks to check on the suitability of health and safety measures that employers have put in place when inviting their workforce back into the workplace. And you'll recall that the Prime Minister announced on the 17th of July that office-based businesses can reopen with effect from the 1st of August. And I think at that stage he was anticipating that there might be some return to old normality before Christmas. But obviously that is subject to the R rate, and we'll just have to see how that carries on over the next few weeks. So today I won't be speaking from an employment law perspective. We have an excellent employment law team here at BDB Pitmans, to which employment law related questions can be addressed, but I will be talking more of health and safety regulatory compliance. So in terms of the legal framework, as an employer, one must protect the workforce from harm, and this includes taking reasonable steps to protect the workers and others from coronavirus. Under Section 2 of the Health and Safety at Work Act 1974, there are duties specified there specific to employees. And of course, this is in addition to common law duties which arise in civil liability cases. Under Section 3 of the Act, that deals with other persons other than employees, so obviously visitors to the premises, contractors, and also under Section 4 of the Act, there are obligations imposed on those who control premises. And section 33 of this Act actually specifies that breach of health and safety obligations under this Act and related legislation can lead to a criminal prosecution. Under the Management of Health and Safety at Work Regulations 1993, employers must undertake risk assessments of work activities that may have a risk of injury. And the minimum employers must do is identify what could cause injury or illness in the business, which are hazards, decide how likely it is that someone could be harmed and how seriously, which is the risk, and take action to eliminate the hazard, or if it isn't possible, then to control the risk. Now, in terms of implications of COVID-19 and risk assessments, in order to take reasonable steps to protect the employees, you must conduct a risk assessment. That is quite imperative. You do not need to eliminate all risks, but you must do everything reasonably practicable to protect your employees from harm, which means balancing the level of risk against the measures needed in terms of expense, time, and resources. So in a situation where, for example, there's a tripping hazard in the workplace caused by a torn carpet, this means that in order to deal with that tripping hazard, you don't need to recarpet the whole area, as that would be an unnecessary and disproportionate expense to eliminate the risk, but you can have it repaired. And employers are required to consult with their workforce. Now, this may mean that if you haven't got a unionised workplace, then employees' representatives need to be contacted and engaged with so that they can actually take part and understand what the proposals are for the safe return to work. And results must be published on the website if there are more than 50 employees. Now, in terms of the results being published on the website, this need only be a summary of the risk assessments. And it may be adequate in order to comply with this if the notice on the website, which must be displayed prominently, is to the effect that we have carried out risk assessments, COVID-19 risk assessments, in accordance with government guidelines, and have put appropriate control measures in place to ensure the safety of our staff and visitors. Now, dealing with control measures, examples of control measures include ensuring hand washing in accordance with guidance, cleaning and disinfecting of equipment and services, increased hygiene practices, making hand sanitizers and tissues readily available, clear and concise signage at all entrance and exit points, detailing the health and safety procedures, maintaining social distancing, currently still 2 meters, staggering shifts, and having reduced numbers of workers on site, and of course working from home, as nearly all of us have been doing. Providing information to employees in relation to coronavirus, and introducing a reporting procedure for symptoms, sending any employees home immediately if they develop symptoms. and ensuring availability of appropriate protective equipment, PPE, usually as a last resort. And if any PPE is provided by employers to their employees, then this must be compliant with work equipment regulations. So, for example, if there are face masks being provided, then they must be of appropriate standard. It's important to keep up to date with the HSE website, as they do issue bulletins on there on a very regular basis. So just a few weeks ago, there was a notice on there about the KN95 face mask, which was found in many instances to be defective. So they've got to be sourced from reliable manufacturers and suppliers. Now, here is an example of an HSE risk assessment from their own website. This is a template. So what we have here on the left-hand side is what are the hazards. And here we have getting or spreading coronavirus by not washing hands or washing them adequately. In the next column, we have who might be harmed and how, list of the workers, customers, contractors, etc., visitors. In the central section, we have controls, following guidance on cleaning, hygiene, and sanitizer. These are the control measures which typically employers would be putting in place in order to counter the hazards and minimize the risk of contracting coronavirus whilst in the workplace. And I won't go through this line by line, but obviously you can review this at your convenience. In the next column, there is provision here for what further action is needed in order to control the risks. So, for example, putting in place monitoring and supervision to make sure that people are following their controls, putting up signs around the office to make sure that they are reminded of their obligations to wash hands in the appropriate way, providing hand washing facilities, etc. The second page, and there's only 2 pages I've put on here, but the risk assessment on the HSE website is more extensive. So on this occasion, we have what are the hazards getting or spreading coronavirus in common use high traffic areas such as canteens, corridors, restaurants, entry and exit points, lifts, and so forth. And the control measures here that they have as a specimen to follow is to follow the employer's guidance. And then in the right-hand column, what further action is required, again putting in place monitoring and supervision to make sure that people are actually following the controls being put in place. And it is important to document your risk assessments and also to allow for regular reviews. And it's extremely important to keep up to date with the HSE bulletins. So just to help put the risk assessment process into context, this slide is a typical risk assessment matrix. It may look quite complicated on the face of it, and it's a traffic light system, obviously red basically for danger. So that on the left-hand side, one has the likelihood of harm. The severity of harm is the bottom axis, and in the event that undertaking the risk assessment provides a score which is between 15 and 25, then it's a high risk activity that should cease immediately. and further effective control measures to mitigate the loss must be introduced. If it's coming in the low risk category, 1 to 6, then these risks are largely acceptable. And so employers must work towards staying COVID-19 secure, and HSE have made available this poster, which has to be displayed in the workplace, confirming compliance with government guidance. So this form, as you can see, it's an automatic tick box which can be downloaded, printed and displayed prominently in the workplace. So it confirms that workplace risk assessment under COVID-19 has been undertaken, and the results shared with the employees. That there are cleaning and hand washing and hygiene procedures in place in accordance with government guidance, and that the employers have taken all reasonable steps to help people work from home and have taken all reasonable steps to maintain social distancing. This has to be signed by a director of the company responsible for health and safety matters, or a senior officer of the company. Health and safety for remote working, and of course by law employers are responsible for the health and safety of all employees, including those working from home, either on a temporary or permanent basis. Now, most people, of course, have been working from home on a temporary basis. How long is temporary before it becomes permanent? Well, the HSE have not defined what they consider to be temporary or indeed permanent, but obviously as time goes on, one has to consider whether this is going to be a permanent state of affairs for employees. And I think that in order to make that assessment, one has to consider the contractual basis. If people are working from home on their existing terms, then they will be deemed to be temporary employees. And it's only when there is a contractual change of terms that employees would be deemed to be working at home on a permanent basis. So HSE has advised that employers should consider how they keep in touch with their employees, what work they'll be doing, and for how long, and can it be done safely, and what control measures they need to put in place to protect employees. So employers should continue to remind their employees of the Public Health England advice, particularly with regard to cleaning procedures of equipment and home working surfaces. They've got to keep in touch with workers and ensure regular contact to make sure that they're healthy and safe. Put procedures in place so that you can keep in direct contact with workers and recognise any early signs of stress as soon as possible. And if there are such signs developing, then that should be documented and brought to the attention of the HR team and followed up as soon as possible. And for those working at home on a long-term basis and using display screen equipment, DSE for short, they should carry out home working and home workstation assessments. And obviously guidance notes should be issued to employees who are working at home. Now this next slide is particularly interesting because this is a slide that's come from the HSE themselves, and this deals with some very helpful home setup tips. So I won't go through everything on here, so we can allow for some more time for questions, but it starts off, as you can see, work on a table. So don't balance it on your knees in front of the telly, on the sofa. Dining table is good enough, they say, but might be higher, a bit higher than your office work desk. So you can make adjustments to deal with that height differential. They say, as portrayed in the picture there, set up the laptop directly in front of you so that there's no twisting in the back. Limit the time for working on your laptop, and it suggests even using a cushion to raise the level of the laptop. Cushion might be a bit high, so you can use a cushion yourself on the chair so that you can basically get the keyboard just below the elbows. And there are other sort of helpful ergonomic tips in this slide, including obviously taking more frequent breaks, breaking up the time you spend in front of the screen, even going for a walk around the garden. And the HSE representative who was providing these helpful tips is the representative in charge for ergonomics. Now, I've mentioned about the HSE, and they have really helpful advice, very detailed advice for employers on their website. This again is a HSE page from their website, and some helpful links that you can look at in due course. So, dealing with DSE risk assessment requirements, tips on ergonomics, working from home, and YouTube clips as well. So as to particular top tips, do please plan for a phased return to work wherever possible, and do engage the workforce representatives in this assessment. Practice social distancing measures, and if this is not feasible, mitigating actions include, but not limited to, further increasing the frequency of hand washing, surface cleaning, using screens or barriers to separate people from each other in the workplace, using back-to-back working or side-to-side working, separated, socially distanced from the others wherever possible. And again, the HSE have got some useful downloadable guides on this. Facilitate extra hygiene practices, provide for increased cleaning of frequently touched areas, sanitizer. The ideal ones, I think, are the standing hand sanitizers, which are foot controlled. So you step and press on the pedal at the bottom and it dispenses into the hand. Review your remote working procedures and practices and the adequacy of those. This is all part of the planning process for a phased return to work and assessing how this could be put into practice. Do ensure that employees working from home are included in all the necessary communications, and ensure that they take some responsibilities as well for looking after their own physical and mental well-being. So carrying on with top tips, and going back to that risk assessment form that we were looking at, do make sure that it's produced taking into account the risks of COVID-19. Of course, obviously, all employers would have had or should have had risk assessments undertaken for their normal working procedures long before COVID was introduced, and accordingly, you should be familiar with the procedure for undertaking risk assessments, and as your previous risk assessments for working practices may be changing, in terms of how the work is done. The previous risk assessments need to be reviewed as well and checked for their adequacy. Ensure that workers and visitors who feel unwell or display symptoms of COVID-19 stay at home and do not attend the workplace. As an employer, you may wish to consider conducting temperature checks to satisfy this requirement. If anybody does become unwell with symptoms, they must be sent home and advised to follow the government guidance and seek medical advice if required. Now, if anybody on site has contracted the virus and recently visited the workplace, the premises should be thoroughly cleaned in accordance with guidance, and the local health authority should be contacted if there is more than one case. As to enforcement actions, this is very important. The HSE and local authorities have the ability to undertake enforcement actions. And I think there's over 360 local authorities which have devolved H&S responsibilities, and they would tend to deal with office-based businesses. HSE would tend to get involved in heavier industry and also some light industrial premises. They do carry out spot checks. They have been carrying out a lot of spot checks, mostly in pinch points that we've mentioned earlier about Manchester, Bradford, Leicester, Sheffield, and there haven't been any prosecutions yet, as far as I'm aware, but they are very much under pressure from unions to make sure that employers are undertaking their responsibilities appropriately. Now, the way in which the HSE or local authority may take action is provide a notice of material breach following spot checks, in which case they would give probably 14 days within which the breach has to be complied with, or they may issue an improvement notice, which again would give a short period of time within which the work practice in question has to be improved and brought up to the appropriate standard. Or in cases where there is a clear breach and risk of injury, and that would include contraction of coronavirus, then they could issue a prohibition notice, which is very serious, and that would mean effectively that that work practice must cease immediately. And again, there'll be a very short-term period of time within which the work practice would have to be reviewed and brought up to a safe standard if there was any chance of persuading HSE or local authority that it was now safe to reintroduce that work practice. Of course, they can also prosecute a company for breach of health and safety obligations, and additionally directors or senior managers. Penalties can be financial, and following the introduction of the sentencing guidelines a couple of years ago, we've seen a severe, sharp rise in the level of fines which are being levied upon companies following successful prosecutions. So these fines can, in the most serious of cases, run into hundreds of thousands of pounds. That would be not in respect of a breach of coronavirus, but those sorts of levels of fines would be appropriate for a serious injury or even death in the workplace. And there is scope under Section 37 of the Health and Safety at Work Act for directors and senior managers even of businesses to be prosecuted. And again, that can attract severe financial penalties and also, in the most severest of cases, imprisonment. There is also the issue of reputational damage of the business to be considered, because prosecutions are public notice, and businesses do not want the local papers or national papers even being aware that they're being prosecuted for health and safety breaches, the reasons for which are obvious. Also, fees for intervention is another relevant factor for businesses to consider, because once the local authority or HSE have issued a notice or written with a notice of breach to the employers, that triggers an entitlement to them and an obligation on behalf of the business to pay their fees. And these fees are £157 an hour. And it's quite clear that these fees can run into several thousands of pounds quite quickly. And in the event of a prosecution that continues all the way through, so at the end of a successful prosecution, such fees can be in tens of thousands of pounds. So it is, in short, better to be prepared, make sure that the company's health and safety documents are all in good order, make sure that the risk assessments are written down and well documented, make sure the health and safety policy of the company is updated, and make sure that it is COVID-19 compliant as well, so that in the event that there is any inquiry, and one has to also anticipate the possibility of whistleblowing by any disgruntled employees, then there is a Bible of health and safety documents available for the health and safety director or office managers to refer to and take the inspector through. Now we've put here some useful links. These are links to government and health and safety executive pages, so it helps you go through what is required to ensure that the business is COVID-19 compliant. I'll let you go through those at leisure after this talk. And of course, if there are any additional questions that we don't deal with this afternoon, then do please get in touch with us and we can deal with those. So we're now going on to any questions. So we've got a question, how much touch point cleaning is sufficient, and how do we make this judgment? That's a good question, and I think that what employers would need to do is have a regular system in place. It has to be, first of all, documented. Touchpoint cleaning has to have appropriate materials, including 90% alcohol. And if touchpoint cleaning is undertaken on a daily basis, at the end of the day, provided that there are materials available to employees to use as they go to the touchpoint sensitive areas, that's including all hard surfaces that they come into contact with, such as in the kitchen or the photocopier. In general terms, that should be sufficient. Again, it should be incorporated into the business's risk assessment process and be documented in that way. So it's a difficult judgment to make, but provided that the materials are available throughout the day and employees understand their obligations as well to clean as they go, basically, that I think would be sufficient compliance. Got a number of questions coming in now. What else needs to happen if someone contracts COVID in the office and is sent home to other colleagues in the office, or further cleaning of the office? Well, as far as that is concerned, if there's an individual case of somebody contracting COVID symptoms in the office, they have to be sent home immediately and advised to take medical advice. As far as communication to other colleagues in the office, it may of course be obvious to them who has contracted symptoms and has gone home, because they're certainly not there, but one should not name the individual concerned to other employees, but notification should be issued to other employees in the office of the incident, and that the person has been sent home and told to take medical advice. You don't need to close the office if it's a single individual case, but in the event that there is more than one incident, you have to make sure that you contact the local health authority, and they will take you through the appropriate procedures. Obviously, there should be additional cleaning of the area where the employee worked. That should be basically taken out of use, and additional cleaning undertaken at the end of the day, or indeed as soon as the chap has or person has gone home, and that can include fogging of the area. Do I have a sense of the relative differences between England and Scotland? No, I'm afraid I don't. I'm not entirely au fait with the obligations, the distinctions between England and Scotland so far as the health and safety obligations are concerned. So we deal with English law and appropriate government advice and HSE advice for England only. Do we have to do a work from home DSE assessment for those who are temporarily remote, is the next question. I would say no, there isn't an obligation to undertake a DSE assessment under the DSE regulations unless there is a permanent state of affairs so far as the employment is concerned. I mentioned earlier about the switch from being a temporary employee to a permanent one on a contractual basis. And although we're now obviously coming up to 6 months on from lockdown and a lot of people working from home, as far as the HSE are concerned, that is still a temporary state of affairs unless it is changed by a contractual change of employment status. And in that event, then that does trigger an obligation for a home DSE assessment to be undertaken. The next question is, my partner works as a barber in a salon and they are refusing to leave the front and back door open to improve ventilation. Given that he isn't able to socially distance and he is in close prolonged contact with multiple people per day, is this likely to be considered reasonable? That is a bit of a nutty one, as they say. One has to consider what other steps the employers are undertaking here for the barber in question, and indeed others in there. Obviously, having the front and rear doors and windows open improves ventilation, but that in itself would not, I don't think, be considered unreasonable, provided that they are requiring the customers to wear face masks throughout their stay, and that they provide the barbers with face protection, face coverings, a visor, and appropriate sanitation and hygiene measures are being followed. Is it satisfactory to ask employees to undertake periodic cleaning outside their own workstation? I think this is a question about whether employees are, whether it could be reasonably required of employees to do cleaning away from their own workstation, of common areas, I suppose. And yes, so far as common areas are concerned, such as the kitchen, a clean as you go policy is a reasonable one, I think, to adopt. And again, it's important to undertake discussions and consultations with the workforce to make sure that they're aware of this proposal and they agree it. It's not quite a case of all hands to the pump, but all employees must understand that they have their own obligations to act in a reasonable manner for the joint good. It's not just for them, it's for their fellow employees, and the more engagement there is, then the better. So yes, I would say it's reasonable to require cleaning away from their own workstation of the commonly touched areas. Next question is, as every office environment is different, what measurement is used to determine whether reasonable steps have been taken to mitigate harm? Well, the measurement really is the COVID-19 risk assessment. If there was an inquiry from HSE or any local authority as to what measures are in place and whether they are adequate, then that would be the usual starting point for an inspector, and the risk assessment would need to deal with the identification of the particular hazard, what the control measures are, what they should be, whether they are adequate, and using that matrix that we looked at briefly, the traffic light system, to consider where on that matrix the appropriate control measures and the risk assessment are concluded, whether it's going to be green, yellow or red. Green, obviously, then that's fine. Others, particularly if it's red, then that procedure is not adequate, and that should be that particular work practice should be completely reassessed. Next question is, does a risk assessment have to be published on a company website? It's not the risk assessment itself, the COVID-19 risk assessment. It's a matter of choice, really. It's not mandatory, but it is important that if you've got a business with more than 50 employees, then there is an obligation to put a summary of the risk assessment results on the company website displayed in a prominent position. And as I say, it can be a fairly simple notice to say that the company has undertaken COVID-19 risk assessments in accordance with government guidance, and that it is satisfied itself that it is COVID-19 compliant, and made the a summary of the results available to the workforce. Other companies have been very transparent and have produced a virtual tome, a war and peace of all the steps that they've taken on their website, and it can run into many tens of pages, including the website, the actual risk assessments themselves on the website. It's a matter of discretion. I've got another question here. In a banqueting venue, if one person reported COVID symptoms, would the premises need to close for a specific period of time, or would a thorough clean of the premises suffice? So in a banqueting venue, if somebody reported COVID symptoms whilst on the premises, that person, and indeed anybody with them, would have to be asked to leave the premises immediately. There would not be a specific obligation for one instance for the premises to be closed for a specific period of time. So yes, I think that a thorough clean of the premises ought to suffice. In the event that there is more than one incident reported, then contact needs to be made with the local health authority to explain the situation and to go through the process, following up with track and trace with the individuals concerned. And so, yeah, if there is an employee who is reporting COVID symptoms in the workplace as well, that individual would need to be asked to return home and appropriate measures put in place. Do students who are gaining an education in a workplace environment also have a personal responsibility for their own health under health and safety law? Depending on their age and what they're actually doing, I would say in general they have some responsibility, but obviously the younger the person, let's say it's an apprentice or somebody on work experience, then the onus is clearly upon the employer to ensure that they provide all employees, and even more so the younger ones who are not perhaps as experienced in general work environments, with full, safe employment. So they would have a limited degree of personal responsibility. They would have an obligation to follow the guidance that the employers are providing, but as in all cases, there would need to be supervision and monitoring. And this is an ongoing state of affairs. So, and it must be documented, and the younger the student, then the greater the obligation is upon the employer. So I think we've come to the end of that long series of questions, and thank you ever so much for those. They're really diverse and interesting. So if there are any other questions, do please put them in now. Otherwise, I think we're finishing just a few minutes before the scheduled end, and the screen's decided to go to sleep now, so sorry for that. I was just going to go on to the concluding page. But so far as our own work is concerned, we can advise businesses on drafting their health and safety policies and statements. Health and safety statements are separate from the health and safety policy itself. We can provide advice on the nature of the risk assessment obligations and who has to carry them out. And in fact, whilst I think of it, so far as who can carry out the risk assessments is concerned, the legislation refers to a competent person being obligated to carry out the risk assessment. So this can be undertaken by a office manager, a director responsible for health and safety, or any third parties. It's quite often, particularly with larger companies, that there are health and safety consultants who are specialists in their field who are asked to undertake risk assessments. And so they could be asked to carry out risk assessments for you, but it's the employer's responsibility to ensure that they cover off the requisite work practices and are compliant, basically. There was an interesting instance just very recently reported of health and safety consultant being prosecuted by the health and safety executive for defective advice. So that is a quite separate issue, but it just goes to show that the HSE are across all these types of issues, and if they find on investigation into working practices that the risk assessments have been undertaken based upon advice provided by a consultant, and they think that that is wholly inadequate, then they can prosecute the individual under Section 3 and under Section 37 of the Health and Safety at Work Act. And in that particular instance, the consultant was heavily fined. So we can advise also and represent clients in health and safety investigations and prosecutions. In my experience, the engagement with the health and safety executive or local authority is most important, and having discussions with them about their concerns, the pinch points, if you like, about what particular aspects of the work procedures are of concern, can lead to a resolution of the inquiry without any prosecution.